Good morning. My name is Maggie Humphrey, and I am the Director of Community Engagement for the Toledo Bar Association. We are happy to be with you all today. The topic of today's webinar is Lawyers on a Nonprofit Board. I'm here with Heather Bradley, the Director of the Center, and she will be monitoring the questions you have throughout the webinar. So please type your questions in the Q&A section, not in the chat box. And we'll have time scheduled at the end for the speaker to answer those questions. Microphones are muted for participants throughout the presentation. It's my pleasure to introduce our speaker today, Dave Arnold. Dave is a partner at RCO Law in Toledo and has extensive experience in the areas of business and commercial law. He's a member of the Ohio Bar Association, the State Bar of Michigan, and the Toledo Bar Association, and earned his bachelor's degree and Juris Doctorate degree from the University of Michigan. Active in the community, Dave previously served on the Board of Education for the Ottawa Hills Local Schools and is a past president of the Neighborhood Properties Inc. Board. He was also a member of the Toledo Bar Association Grievance Committee. He is currently on the Lucas County Mental Health and Recovery Services Board and is a guardian ad litem for CASA in Toledo. Thank you, Dave, for joining us and providing your expertise on this topic.
Thank you, Heather. And Maggie, good morning, everyone. These are the topics that I will be covering in the next half hour to 40 minutes or so. We're going to be talking about general considerations for joining a nonprofit board, some things that I think folks ought to think about and questions they ought to ask and documents they ought to review in the process of thinking about and deciding to join a nonprofit board. And throughout the presentation, I'll be working in some special considerations and issues that lawyers will be thinking about and facing both in deciding to become a member of a nonprofit board and things that they will face as a board member. So we'll be talking about due diligence. We'll be talking about later on the legal obligations of nonprofit directors, simply what the law says about your obligations as a director of a nonprofit entity in Ohio. And finally, I'll just mention very briefly the Ohio law on open meetings because it applies to many of the nonprofit boards that we have in our community. Just by way of personal background, so you'll be able to make your own decision about whether I know anything about what I'm talking about. As Maggie indicated, I've served on a number of nonprofit boards over the last many years. As I think most of you know, there are really three ways that nonprofits recruit and gain board members. One is self-perpetuating. In other words, a board may have a nominating committee and they will find folks in the community they think would be good board members, present them to the other board members and have them elected. There are also statutory boards that require specific appointments by specific public entities. For example, Maggie mentioned that I'm on the mental health board in Lucas County. I was appointed by the Lucas County Commissioners. Other legal entities, political entities in Lucas County have appointment rights to that board as well. And finally, of course, we have elected board, and the example of that would be a board of education, a school board. I also represent a number of nonprofit entities, both large and small, and have done so throughout my years in the community. So let's talk about some of the things that I think folks ought to think about when they are considering joining a board. First and foremost, some obvious things is there alignment between you and the board and the entity's mission, their values and their activities? What is the purpose? What does the entity do? And how does that fit in with what your interests are? one of the things that I encourage certainly young lawyers when I talk to them about being active in the community through board work is to pick a board that you sincerely care about. Don't just simply find a board on which you see a number of business leaders in the community and think, well, this will be good for my business development. I'll be able to interact with these folks and maybe I'll be able to get some work from them. Unless you care about the activities of the entity, your insincerity will show through and it's likely to be counterproductive. So I think everyone, and certainly lawyers, need to think about why they want to be on this particular board, what would be valuable for them on the board, and what skills they can bring, what things they can bring to the board. So you need to find out about the entity. Ask around, ask judges, ask other lawyers. If you're being recruited for a self-perpetuating board, ask the person who's recruiting you. What's their experience been on the organization? And think about whether you are committed. You have the time and perhaps the financial ability to commit to the organization, to actually participate in the organization full throttle and not just show up for an occasional meeting. Some special considerations that I think lawyers should consider before joining a board. Lawyers are popular board members. It's not uncommon for a nonprofit board that's self-perpetuating to think about the professional diversity on the board. Perhaps they want an accountant to help with their finance committee, a lawyer to provide some legal perspective, perhaps an insurance company, perhaps a banker, whatever the needs of that particular entity are. And lawyers are a logical place to look for board members. A recent study in Ohio indicated that lawyers are overrepresented on boards. Lawyers make up 0.6% of the workforce in Ohio, but are 7% of nonprofit board members. So some of the questions that lawyers ought to be asking themselves is, what are the legal needs of the agency? Will they be compatible with your practice area? Now, in a few minutes, I'll be talking a fair amount about role clarity and whether a lawyer on a board is acting as a director or acting as a lawyer. And those are important questions for the lawyer to ask and answer, and for the other board members to understand. And I'll go through why those are important questions. But as a practical matter, we all know that one of the reasons folks serving on nonprofit boards want lawyers on the board is to get the value of their legal expertise. So we know that questions will come up, even if the lawyer is not technically the representative, counsel to the board or counsel to the entity. Questions will come up, and you need to think about whether the kinds of questions, the legal issues that are likely to arise on this board are in your wheelhouse or something that you have some expertise on, because one of the ethical requirements of lawyers is to only to provide advice when it is an area in which they are competent. So you need to think about that. You need to ask, is the organization really looking for a pro bono lawyer, somebody to help it out for free? And because of the difficulties that may arise with some of the ethical and legal issues of lawyers serving on boards, sometimes if the answer to that is, yeah, we really would like a pro bono lawyer, I recommend that the lawyer talk to them very carefully about maybe that it would be better to serve that entity as a pro bono lawyer, helping them with their legal issues rather than serving on the board and trying to wear two hats and juggle those two roles. Sometimes the nonprofit that is recruiting you will have counsel. What is their area of expertise? Is it limited to a particular area that is not going to overlap with you? What do they do? And then there are 4 areas that are specific to lawyers. I'll touch on each of them briefly as we go through this morning. But the ethical considerations are conflicts of interest and independent advice, the independence of your counsel. And then the privilege, the privilege of confidentiality and insurance are the other issues that lawyers are specifically going to be looking at. So let's talk now about due diligence. What are some of the questions that I think anyone should ask, but certainly lawyers are going to be asking of the executive or the current board president, the leadership of the entity that the lawyer is considering, where the lawyer is considering joining the board? Is there insurance, directors and officers insurance? Is it adequate? Do the bylaws provide for indemnification of directors? In other words, protection, legal protection, financial protection for directors who are acting in what they believe is the best interest of the entity, but there's a claim or lawsuit nonetheless. Who else is on the board? What are they looking for? What is the leadership of the entity looking for in a new board member? Some documents that I think anyone ought to review, but again, I think lawyers will be especially interested and will be asking for these documents to review prior to agreeing to join the board. Many of the certainly larger nonprofits obtain annual audits, and the audit reports for the last couple of 3 years will give a potential board member a wealth of information about financial stability, about sustainability of the finances of the agency. But audits also provide management information. As those of you who run nonprofits know, the auditors will look at your management systems, your financial systems, and may make recommendations, may raise concerns and need the things that need to be changed. And one of the things I encourage folks who are considering board membership to look at is, did the past audit raise management issues? Is there a management letter recommending 3 or 4 things that ought to be changed? And then look at a more recent audit and see what management's response was. Was management defensive? Was management agreeable? Did management fix the things that needed to be fixed? If the entity doesn't obtain annual audits, and many smaller ones that aren't required to by their funders don't get an annual audit, you can still get a significant amount of at least financial information by looking at a couple of years of periodic profit and loss statements and balance sheets. Even if it's just something that comes off of QuickBooks, most lawyers are able to read that and glean information off of it. And then the other thing that I'm a very big proponent of is looking at minutes. I think minutes of meetings are very important. What are the issues that are concerning the board? What are the things that the board work on? Is it routine sort of management of the agency? Are there specific issues that you're going to be facing as a new board member? Do the meetings appear to be businesslike and efficient? Is there an agenda? Is the agenda followed? I think it's critical to ensure that any board that certainly a lawyer is serving on maintains minutes. The minutes are accurate. The minutes, you're able to go back and look at the minutes and see what has happened over time. And I think the minutes will tell you a lot about how the agency and the board are operated. Additional documents that I think anyone should review, but especially lawyers are going to be interested in. What are the bylaws? How are the articles of incorporation? What do they look like? Do they have the required tax exempt statement? Again, those of you who operate nonprofits that are tax exempt know that the IRS requires the specific language in the articles of incorporation of a tax exempt entity that primarily describes if the entity dissolves, what happens to the assets of the nonprofit, and ensures that those assets will go to another tax-exempt nonprofit entity and not to the benefit of any individual. If the entity is tax-exempt, then most of you know that there's a 990 informational tax return that's filed every year. You can get a wealth of information from that 990. There is a website called GuideStar that organizes them in a very searchable way by state, and you'll find out a lot about the agency in terms of who's doing what, how much time the board members are spending, who their major contributors are, who their major funders are, what the agency's main contractors are, vendors, things like that, which of course will be interested, a lawyer will be interested in looking at with respect to conflict of interest. If the entity is not tax exempt, it's a nonprofit registered with Ohio, but it's not tax exempt, you may want to find out why. If it's a new or small entity, it may simply be a matter of they haven't needed it because of their funding stream, or perhaps they don't need it because they have access to a nonprofit foundation that is tax exempt. I gave this presentation to a Rotary Club the other day and mentioned this, and they said, well, you know, we can direct folks who want to make a tax exempt donation to the Rotary Foundation, and then that money can flow back to us from the foundation. And it may simply be that they can't afford the $850 fee to file the application for tax exempt status. If it is a tax exempt entity, it should have a conflict of interest policy. You should take a look at that. Most of us who form nonprofits and get to help them obtain tax exempt status use the template that's in the IRS instructions for filling out the form, the 1023 form, to obtain tax exempt status with the federal government. And then the D&O insurance policy I mentioned before, just take a look at that and make sure it's adequate. As you may have been able to discern, I have a strong bias toward treating nonprofit activity, nopprofit entities, and board service on nonprofits in a sort of business-like way. I think it's important to approach it in a business-like manner. That doesn't mean that you don't appreciate the mission. That doesn't mean you don't understand the values, the purposes of the agency. It has to touch both your heart and your head. But I think it's important to have a candid discussion with the executive director and the board chair before you join a board, what their expectations are. Is, you know, get your role clear. Are they going to look to you as a lawyer? Are they going to look to you strictly as a director because they have other lawyers? And then I recommend writing a letter, just a straightforward letter. I'm very happy to accept your invitation to join this board. Here are the things, my understanding of what my role is going to be. You slotted me for the operations committee to start out, and I think that's appropriate. Use of my skill set, I look forward to that. And I understand that you have coverage, insurance coverage, and that you will inform me if for some reason you decide to change that insurance coverage. Just a very simple couple of paragraphs laying out expectations so that everybody has it, it's in writing, and it's understandable. Okay, so let's talk about specific issues with lawyers. Role clarity, I call it. You know, do you have your director's hat on, or do you have your lawyer's hat on? And this is important, and you'll see why it's important as we go through a couple of these additional issues, the issues I talked about earlier about conflict of interest and so forth. But when you speak when a lawyer is asked to give advice or asked to comment on something that is at least related to a legal issue or could be a legal issue, it's very important that the minutes reflect that the other board members are clear about what your role is. Are you giving an opinion as a lawyer? Are you giving an opinion as a director? Or is it some combination? And whatever it is, try to make it as clear as possible. And it may be awkward. It may seem sort of stilted, but I recommend that a lawyer, if this is the case, that say something to the effect of, I'm not the organization's lawyer, and I'm giving this opinion personally as a director and not as counsel to the organization. Certain items that come before a board, as you all know, may be sensitive issues, maybe that you want to treat with confidentiality, and if possible, if they fall within the exceptions to the open meetings rules in Ohio, you may want to talk about them in executive session, in which case the lawyer can be much more open about it. But the end of the day, when a lawyer is asked a legal question or asked to give an opinion or discuss something at a board meeting, the lawyer may need to pause for a second and think about, what role am I playing here? Let's clarify my role. Am I giving you advice as a lawyer on this matter, or am I giving you advice as a board member, as a director? And it's easy to slide into a legal situation. I mean, here are some examples of legal services that you might not think, well, this person who's a board member can help us amend the bylaws. Our bylaws say we have 15 board members. We think that's too many. We want to go back to 11 or 9 or whatever. And surely somebody who works with words all the time and contracts and documents can help us amend the bylaws. That's a legal service. That is something that a service that a lawyer is providing, that he would be providing to a client. Obviously preparing an employment contract for the executive director, but even assisting in preparing the 1023, which is the application for tax exempt status, or helping to prepare the annual 990. Those are legal services. And it's important to understand that a lawyer who is providing that service to the board, to the agency, to the entity, is providing a legal service. And it doesn't matter if there's payment. Payment is irrelevant in terms of an attorney-client relationship. It doesn't matter who's paying or if there's any payment at all. If you're providing the legal services, you've got to step back and think about the context in which you're doing it. So let's talk about some of the specific types of issues that arise. And of course, conflicts comes to mind. If you're representing the entity, whether it's on a one-off, doing a specific thing, or that you're sort of acting as their general counsel, and you're also a director, the lawyer is going to have to make sure that there is no conflict, that no current client or even past client is adverse to the work that's being done for the entity. And if you're doing something for the entity, again, whether you're getting paid or not, whether it's preparing, amending the executive director's contract or amending the bylaws, make sure that you comply, you being the lawyer is going to need to make sure that she's complying with the entity's conflict of interest policy. Remember, I talked about that for the tax exempt entities, you're required to have a conflict of interest policy. Primarily, it's a function of disclosure and ensuring that it's an arm's length transaction, that there's no personal private benefit, and that everybody knows what you're doing. And of course, if you prepare something or you make a recommendation or you encourage the entity to act in a particular way, the lawyer can't vote on that. And the minutes need to reflect that anything that where the board is voting on the work of the lawyer is going to abstain, and the minutes need to reflect that abstention. So conflict of interest is one of the 4 things that I talked about as being important. Another thing that's important is independence. Lawyers' ethical rules require us to provide independent advice. And when you're acting as a dual role as a lawyer and a director, a lawyer is going to have to stop and think, you know, will my position on this board, will my views on a particular topic affect my independent advice if asked to give it? I'll give you an example. Let's say the entity is maybe a larger entity and it's thinking about buying a building. And it's a contested issue. The board is split on it. The lawyer has strong views. Let's say the lawyer thinks that it's a bad idea, that it's something that the entity can't afford right now. She expresses those views very clearly at a board meeting. She votes against the motion to purchase the building, but it passes. It's a close vote, but it passes. And now the executive director calls later that week and says, will you help us with the purchase of the building? Will you provide us with legal assistance in the purchase agreement and negotiating the transaction? And the lawyer has to stop and think, am I going to be able to give independent legal advice on this matter, having expressed myself in such a way as a director? So that's another way in which lawyers have to, again, stop and think, make sure that there is a path forward that is both useful for the agency and ethical for the lawyer. And independence is one of those critical issues. Privilege. I suspect all of you, that even the non-lawyers, understand the concept of privileged communication. It's a key element of a lawyer's work, that there is a privilege that applies to any communication between a lawyer and a client, and even a lawyer and a potential client. But for the privilege to attach, and by privilege I simply mean that the lawyer cannot be compelled to provide information to disclose what the client said in that private conversation. A couple of things have to happen, though, before there can be a privilege attached. One is there has to be an attorney-client relationship. So if a lawyer, this is where role clarity, where the role of the lawyer in providing information, in dealing with issues that come up at a board meeting is so important. Because if there's no attorney-client relationship, there is no privilege. And anything that the lawyer says, anything that's discussed in the meeting will not be privileged. And you don't want to have confusion over the lawyer's role lead to the loss of privilege. And you know, my experience is that oftentimes other directors will simply assume that, well, because there's a lawyer present and we're talking about this, that the privilege applies. It does not automatically apply. And again, it may be a situation where you want to go into executive session and you want to make it clear that the lawyer is providing legal advice in the executive session on behalf of the agency, in which case the privilege would clearly apply. And the final of the four issues that I raised is insurance. And we've talked about it some before, but certainly in larger nonprofits, there are a lot of things going on. There are vendors that provide a significant amount of supplies or services or advice or whatever to the entity, who can become disappointed vendors, right? I mean, if the board votes to switch from vendor A to vendor B, it's possible that there could be litigation. It's possible there could be a claim. It's possible that the actions of the individual directors will be under scrutiny. The entity should have nonprofit directors and officers coverage, D&O coverage for the directors, that provides insurance protection for directors who are taking action as a director as long as they are meeting the basic legal obligations for directors in Ohio, which we'll get to in a couple of minutes. On the other side of the equation, lawyers have malpractice coverage. And so they have insurance, an insurance policy that covers their activities as a lawyer when they are negligent or make a mistake or do something that gives rise to a claim against them as a lawyer. Now, what lawyers on nonprofit boards will worry about, or should worry about in my view, is winding up with the worst of all possible worlds, in which action they have taken as a director on the board is confused as to whether it's as a director or as a lawyer, such that the entity's D&O coverage, the adjuster will say, well, you were acting as a lawyer when you did that, so you're not covered under this policy. And you go to your own malpractice carrier, and your malpractice carrier looks at the minutes and looks at the situation and says, well, no, you were acting as a director. You weren't acting as a lawyer, so you're not going to get coverage from our policy because you weren't acting as a lawyer. We only cover your actions as a lawyer. So that's another reason why role clarity is very important for lawyers to think about, to make clear, to make sure the minutes are clear, and so forth. Now, let's talk for a minute about the legal obligations of all nonprofit directors, lawyers, and everybody else. And it's statutory, it's found in the Ohio Revised Code, and there are two specific duties in Ohio, a duty of care and a duty of loyalty. And this is similar to those of you who operate businesses. You'll recognize the prudent person business judgment rule. This is very similar. And here's the statute. I'm obviously not going to read it to you. I've highlighted the areas that are important. A director is meeting her basic obligations under law as a director of a nonprofit if she reasonably believes that the action she is taking in good faith is in the best interest of the entity or not opposed to the best interest of the entity, and she is taking action with the care that an ordinarily prudent person in a like position would use under similar circumstances. So basically, it's an ordinary care, prudent person for the duty of care, and it's a reasonable belief that it's not opposed to the best interests of the entity for the duty of loyalty. And the statute goes a little further with respect to the best interest and provides some examples of what the director is able to legally is entitled to rely on to determine what is in the best interest. And you can look at this list, the best interests of the employees, the suppliers, the creditors, the customers, the beneficiaries of the services provided by the nonprofit, the economy, community and societal returns, long-term and short-term best interest. So this is what there's a separate section of the Ohio Corporation Law that covers just nonprofits. And this particular statute is taken, in this particular section is taken from that statute and describes what the best interest of the corporation, the nonprofit corporation is. All right. So now I'd like to talk just for a couple of minutes about my observations based on, whatever it's worth, my years of experience, reading the literature about nonprofit board service, thinking about the ethical issues, thinking about, how boards work best, and really just my own personal experiences serving on a lot of different boards. I believe that a board member and the board in general is intended to operate at a high level, is intended to set policy and direction for the entity and not to manage the entity. It seems to me that the core functions of a nonprofit board are to hire and fire supervise and discipline and direct the executive director or whoever is in charge, the management, whatever the top management is, whoever's actually managing the entity. To ensure financial stability, to look at the budget, to make sure that there's sustainability from a financial point of view, that the board will be able to ensure that is existing, that is ongoing. And finally, to ensure legal compliance, that whether it's with the funders, the obligations to the funders, obligations to file the 990 on time, obligations to make sure that all board members have an opportunity to see the 990 before it's filed. Whatever it is, there are certain basic legal requirements that apply to all nonprofits. And I think one of the core functions of the board, of all board members, is to make sure that the entity is legally compliant. As I said, I don't think the board it should be in the business of managing. It should focus on big picture items and not micromanage. Example is the board should approve the budget. The board should be familiar with the finances of the agency, monitor the expenditures, make sure the agency is financially viable. But the board shouldn't be involved in finding a better price for copy paper. It should leave the management of the agency to the managers of the agency, whether it's executive director or whatever the structure is. Avoid back channel communication with the staff. One of the beauties of nonprofits is volunteers, and they're all nonprofits, or most nonprofits have folks who believe in the mission, who are volunteering their time, their energy. They may be in the office a lot. They may be very active in the day-to-day activities of the organization, fulfilling its mission. And often those folks become board members. It's just sort of a natural progression. They volunteer to do the actual work, and then they volunteer and become a board member. What can be counterproductive, however, is if that board member still has relationships with staff and the staff come to that board member to raise issues about the management of the agency. Back channel communication with staff and bringing those things on a personal level to the board can be very destructive. And it's important to, I think, as board members, to respect the chain of command. If a staff member has a concern, the response is to talk to your supervisor about it, talk to the executive director about it, but don't become a lightning rod for staff complaints. Managing staff is one of the most difficult. I mean, most nonprofits, that's really the heart and soul of the agency, right? Is the staff, the personnel. I mean, they're not manufacturing anything. They don't have a bunch of machinery and equipment to worry about. It's the staff, and those are management issues, not board issues. If there are problems with the executive director, if it becomes clear that staff have legitimate concerns, the response of the board should be to the executive director, not to the staff. So I think it's important to have a business-like approach, respect the chain of command. At the same time, I don't want to give the indication that you can't be involved as a board member in the activities of the organization. You should be a cheerleader. You should cheer when things do well. You could recognize achievements. You could recognize staff who go beyond. All of those things are important for board members to do. I just don't think you do them to the detriment of other things. Finally, how formal should board meetings be? They're typically not formal. You may find some old code of regulations or bylaws which say you're supposed to use Robert's rules. Typically, you don't unless it's a very contentious matter that you want to have a very specific and orderly way of approaching. But typically, the board meetings can be informal, but they should be businesslike. They should follow an agenda, and the minutes should accurately reflect what happened at the board. Finally, I'm not going to go into any details about the open meeting laws in Ohio, the Open Records Act in Ohio. That's sort of a separate program in itself. But I do encourage you, if you have questions or concerns or want to learn more about open meetings in Ohio, this resource, as Dan Dockich would say, is not a good resource, it's a great resource. The Attorney General every year publishes what's called Ohio Sunshine Laws, and there's the link to it. You can download it, print it, look at it online, but it covers all of the open meetings and open records acts in Ohio with case citations. It discusses each topic, describes how you go in and out of executive session and so forth. So I encourage you, if you have questions or concerns or just want to learn more about open meetings in Ohio, that's a good resource. Okay, I think I've hit the time pretty well. And Maggie and Heather, I'd be open to any questions.
You sure did hit the mark there, Dave. Thank you so much. I don't see any questions in the Q&A box. I didn't see anything accidentally land in the chat box. So who has questions? I mean, hey, you got Dave all at your disposal here. Who either wants to put a question in the Q&A box or perhaps even open up your mic and ask a question directly. Does anybody have a question? Well, just while you're thinking about that, I'll direct your attention to the chat box. There's a couple of things that I threw in there. So there's an upcoming webinar from the Toledo Lucas County Public Library, and it's telling your nonprofit story with GuideStar. And David had alluded to that a lot of people do use GuideStar for research. So you want to make sure that you're controlling your story out there. Also, they fairly recently introduced some type of an evaluation process of the completeness or thoroughness of your profile on GuideStar. So if that's something you're interested in, I included the link there in the chat box for that. I know many of you are aware of this, but as a reminder, we do publish a no-cost board governance and best practices checklist. The link is there. There's 9 sections in that. Many of the points David covered, but in addition to the board governance piece, there's 8 other sections. And on that link that I put there, there are direct links to an associated page just chock full of resources and links for each of those topics. So if you're interested in that, you can check that out. And finally, there was reference to DNO coverage, and we do have a local agent. I'm sure there's lots of them out there, but if you want to fill out an online technical assistance request form, I can get you that person's contact information, and there's the link. And in fact, you can fill out a technical assistance form at any time if you have questions, and we'll try and get you an answer or the resources through that process. Okay, so there's a couple right there. Anything? So I don't see any. David, you must have done a really great job because we don't have any follow-up questions at this time.
Okay.
Dave, I have a question for you. You had mentioned that if you're on a board and someone from the staff comes to you, that you really don't want to be a lightning rod for their concerns. How would you suggest that the board member handle that situation if staff is coming to them complaining about management? How would you kind of suggest redirecting that or handling that situation?
I think it's a 2-part process. The first part is to encourage them to go to their supervisor, to use the chain of command. But I think the second part is to say, look, we care about the agency. We want it to be successful. We want you to be successful. If there are impediments to your success, if there are real concerns and we get these concerns from others and it becomes an issue, be assured that we won't ignore it. We'll take care of it, because I think that second part is important, because I think sometimes staff perceive the board to be close to the executive director, that there's a relationship. maybe between the board chair and the executive director, and they're concerned that there won't be any real look at a problem. So I think it's a two-part thing. The initial thing is to deflect back to the chain of command, but also to make an assurance that, I wouldn't say it this way, obviously, but if we find out that it's more than just one disgruntled employee and there's a real problem here, we won't ignore it.
Great.
Okay, Patty has a question. How do you find lawyers who might be interested in serving on boards?
Well, I think Maggie has a connection that is a way to do that. I think, a lot of it's word of mouth, a lot of it's your personal connections. I think, I've encouraged folks in our organization who are interested in boards to look at Epic. Frankly, call up Allie Sterling, who I think, has her finger on the pulse of a lot of nonprofits, folks who are looking for board members. And just ask, are there board? Have you heard of boards folks who are looking for board members? So I think if you're an organization who is looking for specific types of folks to be on your board, like lawyers, I think going to Maggie, going to Epic, and saying, "Would you please think of us if you get inquiries?" would be a good way to do it.
Yeah, so that's a great segue. We have, the reason we're doing this presentation is that the Bar Association has a program called Nonprofit Connect, where we try to connect our attorneys to local nonprofits. So in the past, that has meant webinars like this, and it's also meant providing pro bono legal assistance. I would say that if you're a nonprofit that's looking for a board member, I would welcome you to email me, and I can look for ways to get that information out to our group to see if someone's looking to serve on a board. I would be happy to try to facilitate that. My email is mhumphrey, that's HUMPHREY @toledobar.org. I can put that in the Q&A as well, but that'd be a great way to try to connect our attorneys to other ways of getting involved with nonprofits.
And building on that, Maggie, I know that some of you are aware on this call that Epic in particular runs, they've changed the brand of it, a board fair. Last year it was virtual and it was a matchmaking service. So you might want to get on the list of Epic and find out when those types of programs are available, those opportunities, but also reach out to the Epic director and just make them aware that you might be looking for someone with a specific set of qualifications. Yeah, great. We, for those of you who don't know, we have a job center that is the most visited webpage of our site by far. Like the second next visited isn't even close. We have, and I don't have an announcement for you today, but we have asked on occasion, should we be doing something similar for board recruiting? So it's not definitively no, but that's something that we're just evaluating. So if you're not on the no-cost e-news that we send out from the center, I would encourage you to do that. That's where we make all of our announcements. And you can go to the homepage and just scroll to the bottom and sign up if you're not on our e-news distribution list. Okay, anything else? No, well, I want to thank David for sharing his time and expertise. We always love it when we can have folks come and share their expertise with the nonprofit sector. And we really value our relationship with Toledo Bar Association. This is just one dimension of our work together. And we know that that can be challenging, particularly with the smaller nonprofits. So thank you for participating today. Noted in the chat box, we'll be sending out the slides and also a link to the replay when it's available, or you could find it on our blog when it gets published or our YouTube channel. All right, so I hope everyone has a great week and we will catch you back here for another webinar opportunity. Thank you, everyone.